Okay, real good. We are back in session at the City of Grant June 25th meeting. Sorry about that. We're having some technical difficulties with our sound system. As you might realize, we really don't have air conditioning in the building and some of our equipment is overheated. So we'll be looking at that later. But let's move to another happy occasion, which is the swearing in with the oath of office, Mr. Ben CORNETT, our newest council member. Ben?
Thank you, Mr. Mayor. I will take the swearing in of the new council member. Can you hear me okay?
Yes, sir.
All right. First of all, Mr. CORNETT, congratulations on your appointment, and we will now administer the oath of office. So please raise your right hand and repeat after me. I, Ben CORNETT,
I, Ben CORNETT,
do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and of the state of Minnesota,
and of the state of Minnesota,
and will faithfully discharge the duties
and will faithfully discharge the duties
of the office of council member
of the office of council member
of the City of Grant
of the City of Grant
in the County of Washington
in the County of Washington
and the state of Minnesota
and the state of Minnesota
to the best of my judgment and ability.
to the best of my judgment and ability.
Perfect. Congratulations, and the clerk will have an oath for you to sign.
Thank you, sir.
Congratulations, Ben. There you go, Ben. All right, we got a new member. Do I have a motion to approve our regular agenda, please?
Not for me. Motion to approve the agenda.
Oh, thank you, Ben.
Hey!
Busy.
Do we have a second?
Second.
Thanks, John.
Aye.
Councilmember Rock.
Aye.
Councilmember Gaper.
Aye.
Councilmember CORNETT.
Aye.
Mayor Huber.
All right, thank you, Kim. You've all had a chance to take a look at our consent agenda and the bill list. Do I have a motion to approve same? Oh.
Motion.
Jeff, we got a motion from Mr. Giefer.
Second.
Second from Ben.
Councilmember Carr.
Aye.
Councilmember Rock.
Aye.
Councilmember CORNETT. Gaper.
Aye.
Councilmember CORNETT.
Aye.
Mayor Huber.
Thank you, Kim and I. We are going to turn right to our engineer, Brad Reifsteck, regarding a consideration of a guardrail project. Brad, I hope you can hear us. We can hear you. Go right ahead.
Thank you, Mayor, members of the council. Again, we're seeking a motion tonight to approve H&R Construction Company for installing plate beam guardrail along Kimbrough Avenue and Jarvis Avenue. The proposed guardrail improvements are an important component in providing safe roadways for the citizens of Grant. Like I mentioned, there's two locations. The first location is along Jarvis Avenue, just north of 60th Street, to protect vehicles from going off a steep embankment into a wetland complex. And the second location is over on Kimbrough Avenue. There's actually three locations on Kimbrough. The first one being just north of 75th Street to protect vehicles from going into a wetland complex just east of Kimbrough Avenue and just north of 75th. And then a second location probably a quarter mile north of 75th Street there. We're proposing guardrails on both sides of a large wetland complex, again, to protect vehicles from the steep embankment. So we did go out and get quotes. We solicited quotes from two contractors that have done previous work in the city of Grant. We received quotes from H&R Construction in the amount of $38,500 and a second quote from Insight Contracting for $53,625. City staff is recommending awarding a contract based on those results to H&R Construction in the amount of $38,500. And we are proposing that this work is funded using the special roadway funds of the city of Grant. So with that said, I would be happy to answer any questions the council may have.
Thank you, Brad. I appreciate that. Looks like you got a good price. Any questions from this side? Ben, Jeff, Tom, John? Okay, real good. Then you just looking for a motion on this, Kim? Yep, real good. Gentlemen, looking for a motion to approve the bid at 38.5.
You're turned down there somewhere.
Yeah, Tom's hiding over there.
I'll make
Thanks for
Motion
stepping.
to approve the bid for 38.5.
Second.
Oh, okay.
Councilmember Carr.
Aye.
Councilmember
Make me work up.
Yeah, aye.
Councilmember Baker.
Aye.
Councilmember Cornett.
Aye.
Mayor Hubert.
Aye, thank you, Kim, and thank you, Brad. Let's move right into big event of the evening. Consideration of amending chapter 32 zoning regarding minimum lot size and dimensional standards of existing lots on record. Tom, do you want to explain this? You kind of championed this to get it on the agenda. If you could talk to us about it for a minute.
Thank you, Mr. Mayor. Yeah, I don't like getting sued, and I don't like taking away people's land rights. Especially don't like getting sued. So I guess to me, this is a two-part deal, you know, whether we can tell people they can't build on their smaller lots. I think in the ordinance, I think it did a really good job. They did A, 5 acres, and then they did B, you had to combine the lots. I think that was great. If you have 1 acre lots, combine them. Our assessor, looking at the assessments on some of these lots that are next to each other, has done that. One lot would be worth 232,000, the other would be worth 14. So the assessor knew what our ordinance was. I think the issue is, what about the lots that aren't adjacent? You know, what about the one that's sticking out there that's 2.2 acres and we could get a house on it, more tax base, more residents? Do we just say you can't build, or do we do what they did for lots that are 2.5 acres and they took a lot of exceptions to frontage, all that stuff? That didn't matter. You didn't need a variance for that stuff. So do we want to do that for the smaller lots? So it'd be, you know, 1, 2, and then add 3, or do we not? And that's a council decision, of course, but I was curious what the attorney thought. And there are 2 lots right now out there that are smaller. One of them we already voted on, and there's another one, just so everybody knows, that are smaller that have offers on them right now. So just so you know. So I'm done.
Yep, that is true. There are offers out there. We'll talk about that as we move forward. Do we have Jennifer on the line, Kim?
Yes.
Good evening, Mr. Mayor, members of the council.
Jen?
Good evening.
So I did prepare a memo that was in your packets at your last meeting. Would you like me to go through that as an overview, or how would you like me to proceed, Mr.
Well,
Mayor?
there's nothing wrong with doing that overview, particularly interested in the progression of both township and county to city setting their own development ordinances. So, and how that's changed, and you could even, I mean, you can go all the way over it, Jen. You tell me what you're comfortable with in terms of covering this.
Okay. Thank you, Mr. Mayor, members of the council. So what I'll do is I will try to keep it brief, but I will kind of give a little bit of an overview of exactly what's in our ordinance today, and then as well as sort of how it came to be, or basically my understanding of how it evolved and came to be. So as Councilmember Carr referenced, we had a concept plan that came before us that we took a look at in terms of a substandard lot, or a lot that was less than 2.5 acres, and talked a little bit about whether or not variances would be acceptable on that particular property. While you did indicate whether or not you would be comfortable with that or not, there was no formal vote that was taken because it really wasn't an application. What we had was basically an overview. So I just want to make that clarification in case someone were to come back with that particular property. There would be additional analysis that would need to be done to determine whether or not it would qualify under our variance criteria. So as it stands today in our ordinance, we have a minimum lot size of 5 acres, which everybody is well aware of. And then we have basically a section that establishes some exceptions or exemptions for existing lots of record. Those exemptions are tied to specifically ordinance changes that occurred over time, first in the township and then what were adopted by the city. So those exemptions really were tied to when the city, and at the time it was the township, determined that it would go to 5 acre lot minimums. And so that 5 acre lot minimum was a doubling essentially of what the minimum lot size was up until that point. So between the years of approximately 1968 and 1983, the minimum lot size in the city or the township at the time was actually 2.25 acres. So 2.25 acres. Prior to 1968, I don't have a record of exactly what the minimum lot size was. However, I do know that it was well below that from the standpoint of that was pretty universally accepted because it was actually pre-Metropolitan Council. So it predated when the Met Council was established. That's important because the Met Council was established in 68, 69, and one of their primary charges when that establishment occurred was that we had a sanitary sewer problem and we didn't have coordinated efforts when it came to sewer. So in the late 60s, they said, we need to fix this. We need to come up with some policies to protect our water bodies and to ensure that we're not contaminating groundwater and surface waters. And part of that strategy also applied to individual septic systems, which of course we know is what the city of Grant is fully on. So from that perspective, they established minimum lot sizes, and at the time it was about 2.5 acres, which is consistent with what then the city or the township at the time adopted. So that minimum lot size was directly correlated to the policies that were going in place at the Metropolitan Council, which was actually, I think, called the Metropolitan Sewer Commission or whatever it was at the time. And it was very deliberate, and it was intended to ensure that we created lots in areas that had appropriate or adequate area for septic systems to support those primary and secondary sewer or drain fields, excuse me. So from that perspective, the township at the time very closely followed what the regional policy was at that Metropolitan Council level as it was getting established. And so between 68 and approximately 83, we had a minimum lot size that was in that 2.25 standard to ensure, obviously, that we had those septic areas available for each of our lots. So we've kind of got these three different distinct periods in time. We have prior to 68, when we've got much smaller lots in some cases. We've got between 68 and 83, where we've got about 2.25 minimum lot sizes. Then we fast forward to 83. That is when we get the minimum lot size of 5 acres, which is where we are today, obviously. And so from what gets exempted and what is an existing lot of record, those periods are very important, especially as we evaluate whether or not lots are buildable or not. And obviously that is just one piece of the analysis that we complete in terms of when that lot was created. And so the exemption that exists in the ordinance today for lots that are 2.5 acres, at least 2.5 acres, mirrors that change that occurred essentially in 1968. And what our exemption also says is if it's less than 2.5 acres, then it must be combined with an adjacent lot of common ownership, which is what Councilmember Carr was identifying. Now, over time, you can see throughout the city that smaller lots have been acquired by adjacent parcels. In fact, it's a very common occurrence across the whole city. And when we performed the analysis on our side, we looked at it specifically for lots that were less than 2.5 acres and lots that did not have common ownership with an adjacent parcel. And during our analysis, we identified approximately 6 parcels that met that criteria. All other lots that were less than 2.5 acres were actually then had common ownership with an adjacent parcel. And so we did not do an a value assessment because that really doesn't fit into our analysis from a zoning ordinance perspective. But what we did do is look at the common ownership, the size of the lot, and whether or not they were owned by common property owners to determine how many of these isolated incidents or parcels do we have out there today. And as it stands, we believe we have about a half a dozen. So, you know, if you give a little margin of error, we're somewhere in that 6 to 10 lot range, if you will. And so from that perspective, the exemption was very specifically tied to the history of the ordinance and how it evolved from 68 to today. And so as it stands, which is what we discussed when this property came forward a couple weeks ago or a couple months ago, as it stands, there is a process that if there's a lot that exists out there that we can go through. And that process is a variance process, and it would be a variance from a specific standard. So if, for example, someone came forward and they had 2.2 acres, as Councilmember Carr referenced, we would take a look at that and say that might be a deviation from that 2.5 acre minimum. But if that parcel was platted prior to the time that we enacted the ordinance, first of all, and it was deemed buildable at that time, which if it went through a plat process, for example, it likely was, it met the standards, et cetera, the deviation would be from the lot area and likely not from a lot of the other standards. And as long as they could demonstrate that there was adequate area for septic systems, et cetera, we would certainly have to give a lot of analysis to whether or not that variance criteria is met. But it would need to go through that variance process. But it's certainly not establishing that any lot that is less than 2.5 acres is not buildable, because a lot more analysis would need to go into that, and it would require a variance. However, there is that process that's available for those lots that do exist in that case. So from that perspective, the history becomes very, very important, even when we go through a variance analysis process. And we would obviously tie it to what those major timeline thresholds were. So 83 and 68, and whether or not the lot was created, and what period of time in which it was created. Now, as Councilmember Carr suggests, the other alternative would be to take a look at the ordinance and say we need to make some adjustments, and we would rather see that, exception statement, instead of being 2.5 acres, to be some other number, whatever that is, whether it's 1 acre, whether it's 1.5 acres, I don't know what it is, but that would be another way to address it, would be to change that exemption. Now, the one thing I see with that, and our city attorney, Mr. Vivian, could certainly weigh in. Right now, we've got it very tied closely to the ordinance changes and to those time periods. So we tied it to the fact that in 68 things changed, and then we tied it to the fact that in 83 things changed. And our lot sizes, those exemptions were pretty closely tied to those changes, both at the regional level and also the local level. And so we would want to be very deliberate in why we would choose a different number, because the number that is given today, you can trace the history as to why those decisions were made. So we would certainly want to take a look at that if we were to start making some of those amendments or changes. So hopefully that summarizes everything that's in the memo. I'm happy to answer any questions. I know we're going way back in time here if we're all the way back in the 60s, but that is how far back we have to go to kind of take a look at where some of these standards came from. So with that, Mr. Mayor, I will toss it back over to you, and I'm happy to answer questions.
All right, thanks, Jennifer. That was good. Yeah, there are going to be some questions. At least I have some. Gentlemen on the end of the table, Mr. Giefer.
Yeah. Any changes we would make, Jennifer, would they need to be approved by the Met Council?
Mr. Mayor, members of the council, likely no. They do not review our zoning ordinance per se, but what they do get involved in is if there were, let's say hypothetically, a grouping of lots that suddenly were being built at 1 acre or 0.5 acres or something of that nature. They do look at like plat monitoring, and they start to look at building permits. So it's not to say that they would review it. They would not have the authority to say we could or couldn't do it in our zoning ordinance. But we are required to make sure that our zoning ordinance is consistent with the comprehensive plan. So we would need to be able to defend why that change occurred and why it is also consistent with our comprehensive plan. That likely would not come up until we were to do our next comprehensive plan, which would be 2030, which is actually not that far away when it comes to the comprehensive planning period. But the short answer is no, the zoning ordinance does not go back to the Met Council. However, that's not to say that they would not become aware of it through other means.
So let's say they would become aware of it. Would that tend to sway them more towards looking at bringing in a public sewer and water to grant or less?
So, Mr. Mayor, members of the council, I'm not sure that it would actually do either. They very well might voice concern over smaller lots to make sure that they can be adequately served by septic systems. The main concern that they have, especially in areas that are not within the urban service area or the long-term service area, is ensuring that they're not going to be put into a position that they have to bail you out. That has occurred over time. That's actually occurred in quite a few communities in Lake Elmo, for example. I'm sure you're familiar with some of those around the lakes, et cetera. The bailout situation becomes very expensive. And it is not something that they want to have to enter into because it costs a lot of money. If they do have to bail out, then that is when they start to say, we need a sewer more than just this bailout area to make the cost of the pipe work. So from that perspective, they may have something to say about it, especially because in our community designation, we are supposed to be at 4 dwelling units per 40 acres. But they also do acknowledge that there are certain times where we've got existing lots of record that predate several of the ordinances, the comprehensive plans, et cetera. So they're not likely to get involved on a one-off basis, for lack of a better way of saying it. But if we had a collection of lots, for example, that certainly could become a discussion item for them.
So we would need to make sure that if we were to make any changes, we wouldn't want to put ourselves in a situation where we'd be down the road requiring a bailout.
Right, absolutely. You would want to prevent and eliminate that to the extent possible. So, and as we all know, smaller lots, the biggest thing is making sure you have enough space for a primary and a secondary drain field. And that's also state rules 70/80, which also requires that. So from that perspective, we have to be very careful to make sure that whatever lot size on that existing lot of record, that we would be consistent with both the state rule and the Met Council rule when it comes to that.
The lot line readjustment process that we've used in the past, where we have a larger parcel, a small parcel, same ownership, they put them together in order to do a buildable lot. What normally does that run someone doing a lot line adjustment? Just a guess, is it $1,000, $2,000 to do the research, to do all of it?
It's probably in that neighborhood. I can think of actually over the last, 12 or so years that I've been with the city that we've had actually, I can think of, 3 or 4 where folks have purchased the adjacent parcel or, consolidated or combined lots to get up to that 2.5 acres. Particularly, I can think of up in the Withrow area, for example, where we had all of these very small lots and folks said, we want to make this buildable. So they purchased additional smaller lots to get themselves up to a place where they would get up to that 2.5.
They met the standards going through the standard process, avoiding the variance process, right?
They achieved it through that. That's correct. There's certainly, I can think of 2 times maybe in the past 10 years or so where we've had folks who have said, I'm not sure if I can quite get there if somebody wouldn't sell them the property, for example. And it's in those cases we've talked about, well, if let's say you get to 2 acres and you can demonstrate it's buildable, then you would need that variance from the minimum or from that lot size standard. However, basically do your best to get as close as you can. And actually they've ended up being able to get there. But we have talked to them about the fact that that would require a variance.
Well, to make it easier for people who may be watching, people in the audience, the way I tend to think about these types of things is it's a funnel. The ones that have the land, they have the 300-foot circle, they have 300 foot of frontage, they've identified 2 septic sites, right? They're in the wide part of the funnel. As you go down further and further, you get to smaller and smaller lots. That's where you get the variance processes. And that is, for lack of a better term, a bit of a gamble, because Jennifer and city staff are going to have to put a lot of time and effort and money into those land use applications. Okay, so most of those aren't gonna make it through the end of the funnel, those small ones. It's just not going to happen. People can buy them, they can combine them, they can do all kinds of things with them, but making them buildable just as a part of actually redoing our zoning and trashing the comprehensive plan, that's pretty problematic, and I worry about that. Once that happens, what Jennifer didn't really get into, and I wish she would have a little bit more, was what happened in Lake Elmo. And when Lake Elmo had permitted all those smaller lots and their septic started failing because there was only one, there's no place to put a second one. What happens with the Met Council? Well, they raise their hand and say, we're coming in to save you. Here comes the cavalry. Well, the cavalry brings with it pressurized water and sewage. And then you are forced to start breaking up these large lots. You are forced to become Woodbury or Lake Elmo or someone else, and you have no choice. This is the danger of not following a comprehensive plan and making sure that your development rules are closely mirrored in that comprehensive plan and the way that the comprehensive plan is approved by the Met Council and is, for lack of a better term, it's a cooperative process, but it is imposed. It's imposed. They're appointed by the governor, so it is an imposed situation and agreement. So that's what I worry about. The city already has multiple processes to handle this problem. And I heard someone say, well, I don't want to get sued. You're going to get sued if you tell these people they can build on one and all these other people spent money to combine lots, right? All these people spent money, went through the planner, and we followed your process, and then you allowed these other people to do this with none of the hassle, none of the problems, nothing else, because you changed 32. We want to be compensated. That's what I would do. I'd send the city a bill if you did that. Moving forward with this, the process remains there for citizens, landowners to take the initiative to go for that variance. Variance is not an impossible process, but variances are granted. Are they rare in this city? Yes, they are. Because if the staff can't look at something, and Jennifer made a good point, it's 2 acres, it's 2.19, it's, those are probably more likely to make it through the funnel, right? They just make more sense. They have 2 septic sites, they could probably get a 300-foot circle on, they may even have all the frontage, right? So those are more likely to get through. That's why it is, frankly, a real bad idea to move away from what we're doing right now. It's a plan that has evolved as the city was a township and the county was doing all of our permitting into its initial city phase. And then as we move forward and we started to develop better and better policy, that's where we sit now with a professional planner who can look at this stuff. So, deviating from that is going to be problematic on a number of different levels. The other thing I will say too, and I just want to wrap up my comments with this, I did notice there were a couple of substandard lot sizes for sale in Grant and actually contingent. And one of them said on there, build your dream home. And I went, someone doesn't understand what's going on here. They have no clue what's going on. So I got a hold of these guys and told them that neither I, your neighbor, anyone on this council can tell you that those are buildable lots. We do not know. It has to go through that land use process in order to know. And make sure that you're disclosing this to everyone in this transaction. You're contingent, so you better be disclosing this stuff, right? And one of them said, hey, great, thanks. The other one I haven't heard from yet, so I'll give him a call tomorrow and see what he has to say. But this is a very dangerous thing to do. The reason that Lake Elmo was built up the way they are and they look the way they look and not like Grant at all is this exact scenario. This scenario. Will the Met Council know? We don't know. The Met Council know about 5 minutes after we do something like that. We don't know. So further discussion, John, Tom,
I think
gentlemen?
Jeff had his hand up unless you want to.
No, go ahead, Tom.
Right.
Yeah, go for it.
Right. No, I get it. I don't look at this as a Met Council thing. I mean, we're talking 6 to 10 lots scattered around the city of Grant. That the Met Council didn't say we had to get rid of when we went to our 5 and 10. So that's, and Jennifer said that. As far as doing the the variances, yeah, we don't like variances in Grant, and you just said it, Jeff, that it's very expensive for the residents. And when I brought this up at the last meeting, that's what I talked about. I go, why don't we give them the same exemptions we get for 2.5 acre lots? I mean, and as far as the septic goes, they've improved a lot since the 80s. And you can probably put just multiple different kinds of septic systems. We don't give those, the county does. So it wouldn't be up to us. So my thing would be, I said, want to give variances because it's expensive for the residents. There aren't that many scattered around. I think it's kind of a non-issue with the Met Council. I guess Jeff differs, but that's fine. And so I thought we'd maybe clean it up a little bit, put one more section in there just for substandard. But if we can go through the variance process, I agreed with everything Jennifer said. And she said it's just, so these lots are not buildable. They just have to go through a process. So if that's what the council wants to do. I was just curious what the attorney would say. That was my only other question. I just wanted a legal opinion on that. But I don't disagree with what Jennifer says. And if the council wants to just go with the variance process, something we don't do often, then we can just do that individually for these lots. And that's fine. I just thought we'd save the residents some money and what it was headaches. So.
Well, I just want to make a quick comment on Jeff's turn. First of all, the Met Council does not make private lots and private ownership of lots disappear. That's not within the preview.
No,
You
I know what they
1
did.
acre lot. You got a 1 acre lot, we're going to make it go away because you can't build there. That's not what they do.
Right.
Someone could do something else with it. So they don't do that. The point of building on the 1 acre lots, Tom, to make it just crystal clear, is that the problem is not building on it. The problem is 10 or 15 years down the line when someone hasn't taken care of their septic fails, now they're sitting on a $500,000, $750,000 house, needs to be rescued. How does that happen? The same way it happened in Lake Elm. Well, they come in.
I defer. I can, if I can comment on that.
Please.
Yeah, no, they don't do that. Worst case scenario, they want you to build on a fresh piece of ground. I've done this in multiple transactions and different people.
What if the neighbor doesn't want to sell?
They don't have to sell. So if the septic goes, they can, as a last resort, dig it out, bring sand in, and replace it in the exact same spot. We've actually had someone do that. So it's possible. So I don't think it's going from the septic fail to city sewer and seawater. I think there's some interim spots. But that's just, I work with that. That's all. But and again, we're talking 6 to 10 lots. They're scattered everywhere. And who cares? I mean, that's my thought. But that's fine.
Someone
also wants to do something different.
Someone definitely should have told Lake Elmo about that plan. Well, go ahead.
If you guys don't have any more questions for Jennifer, I was going to ask if we could hear from Nick.
Yeah, that was next. I just wanted to get the
My
right
question is
answer
for Nick.
down.
So,
Yeah,
okay.
exactly.
Nick, we're gonna call you up and ask you a legal question here.
Certainly.
Hi, Nick. Who wants to go first? Jeff, I guess you. That's all right.
Oh, I didn't know if
If you're
Nick
not
was going to,
ready.
I'm ready, but I thought Nick was going to say,
Presentation on this part?
Yeah, no,
This is
okay.
Jennifer's purview.
okay, so, Nick, when we talk about like the potential getting sued, is one of the, potentials is we get, sued by people that were forced to combine lots, as Jeff said. Is that a reality? And I have a second part to that question too.
Well, I mean, anybody can sue anybody for anything, right? I mean, that's just kind of the world that we live in. That being said, I think your ordinance is clear, and I think Jennifer did a really nice job of tracing the ordinance back to sort of the watershed moments in history which relate to smaller lots. I've been in and around Grant for a long time. And one of the things that has always been a top priority is keeping the density of lots, the 4 per 40, intact and just maintaining the integrity of that degree of density, which is where a lot of this is born out of, right? You can have smaller lots, but you've got to maintain the density. We know that historically, going back, that there have been some smaller lots, which is really what the existing ordinance solves for and provides a process for. Council member Carr is not wrong when he says we can, as a matter of policy, change the ordinance. That's, if the council looks at it from the perspective of policy and wants to allow for smaller lots or wants to change the density, it can certainly do that. It has the authority. But that's a policy determination that gets made by the council, and I think that's how he stated it early as he was kind of talking about this. But the fact of the matter is that these ordinances have been on the city's books for a long time, and so if there is a sale of a small lot in the city of Grant, it would certainly be advisable by anybody selling those lots to consider the terminology that they're using when they're marketing the lots. And then secondarily, before anybody buys a lot or puts in a non-contingent offer without, doing inspection or diligence, they should call the city and make sure that the lot truly is buildable. And it's not so easy as to say, yes, something's buildable, or no, it's not. You heard Jennifer go through the sort of the litany of, when is a lot buildable, or when is it not buildable? What are the exceptions and the exclusions, and what might be eligible for a variance? So there's analysis that needs to be done there. So I guess with everything as stated in the ordinances of the city, in particular, everything being tied to well-identified dates, I'm not overly concerned of the risk of a lawsuit because the defense is going to be the ordinance was on the books, the city didn't change anything, the buyer has the responsibility to do its diligence, the seller has the responsibility to do their diligence, and if there are questions, then they should be in contact with the city to discuss the rights and responsibilities. And in fact, over the last several years, certainly in my time, dating back to about 2006, we've had a handful of property owners ask, is this particular lot buildable? Is it not buildable? And you always look at the circumstances. You always look at how the lot was created and what the density was at the time of creation, and all these various different factors. So if the council desires to change it, that's certainly within the council's authority. But as it stands today, particularly with a variance process available, I'm not overly concerned about the risk of liability.
You done?
Well, I just had one more comment. When I
Yeah.
reviewed
Go ahead.
a comp plan, it didn't seem, if we were to make any changes to allow more development, it would be consistent with the comp plan.
It's not, and they'll find out, that's obvious.
Yeah.
So, yeah, and then they'll come in and bail us out at some point. They would love to have us develop this just like Lake Elmo.
Okay.
I think other folks might want to develop it too. So, Nick, anything else to say on liability? I'm not really worried about being sued by a buyer of a property that is substandard and needs to go through the process. Again, buyer beware, caveat emptor, know what you're buying, and there is a process if you do find yourself in that situation. I will note the two lots I was talking about before are both contingent. What they're contingent upon, I did not know. I did 20 years in the real estate field, retired. I've seen these situations before. You're better off making people aware of what is happening so that we don't have lawsuits, we don't have hard feelings, we don't have people hurt. You don't want to do that. If you can prevent it, you do it by disclosing. So that was the only point on those two lots, Nick. I get what you're saying.
Just one other comment
Yeah,
on
go ahead.
on the comp plan piece. I think that's an excellent point. And you always have to make a determination as to whether your code is consistent with the comp plan. It should be, I tend to believe that the small lots are best dealt with from a variance perspective. And if somebody believes or desires to seek a variance from the city, then they come in and they explain their situation, and ultimately the council then maintains control over whether the facts and circumstances support a variance. And typically, that's going to involve somebody coming in and saying, hey, this is not an issue of my making. This was a condition that existed, well back, predated. I didn't have anything to do with it. And so they're seeking effectively leave or relief from your code. If you look at it in the reverse, and if you were from a policy perspective to change the rules on size, then of course that would apply to all lots of that particular size or parcels of that particular area. And the council would have no further say over those parcels. And so, just sort of thinking about the decision-making process, would you rather just have a blanket rule that allows smaller lots to be deemed buildable, or would you prefer a structure that places the burden on the property owner to come to the council and request a variance or permission to deviate from the code when the circumstances warrant, because they're beyond their control and they create significant difficulties for building. So, the more conservative approach would be to maintain the variance and to utilize that process for dealing with this scenario. But if you wanted to address all smaller lots, that's where you would potentially craft language that would allow smaller lots to be built upon.
Thank you. Tom?
Yeah, and thanks. No, I agree with all Nick said too. I mean, it's just again, when I brought this up, it was more of the variance part. You don't like it, I don't like the variances, but also, as Jeff said, it's going to cost the residents who have those small lots more money, which is fine, I guess. I don't like that one either, but it's that could be. And then we do allow exceptions already for 2.5. So these lots are also scattered. They're 6 to 10. That's all we're talking about. We don't have a ton of them. And so I thought it would be better for the residents to do that. But however, that is fine if we just want to keep it the same way. I totally understand what Nick is saying. The residents will just have to know that. And I agree with Jeff, because when that lot came up that we kind of turned down at the last meeting, not turned down for Jennifer, we didn't turn it down. We didn't know. But first thing I did, a client called me, and not client, a resident called me and says, "This is for sale. Can they build there?" It was a neighbor. And I called him back. I said, "I don't know." And so I called the agent, and he went through the process and went through the land use application. And because I said, just what Jeff said, you better know before you try to sell it to somebody, because we don't want that. We don't want them buying it and coming in here begging and pleading they were going to build. I don't want that. And as Jeff said, same thing. So, and this other one I also talked to, so yeah, and they know that too. So, but yeah, no, it's fine then. If that's, I just wanted to make sure we talked about it, got a legal perspective, and thanks for Jennifer and Nick for weighing in on that. That makes total sense. And I kind of know where we stand with it anyway. So, and that, in my opinion, I change it, but that's, I don't think the council's going to, and it's fine. We don't have to.
You change it back to the.
I think I would just,
No.
all I would do is add that third section, because we have A, 5.5, 5 acres. We have B, if you can combine the 2.5, which I'm 100% agreeing with. But then the section is, what if you can't? And then just add something there with the same exemptions that the 2.5 acre lots get for frontage and all that stuff. And the one bottom line, because we're all concerned about the sewer, and I hear that about the Met Council and everything, but we don't give out sewer permits. The county does. So if you can't build on it, you can't build on it. And we don't give variances for sewers, septics.
But that's
so anyway, just what I'm
yeah,
saying.
gotcha.
I agree with what Nick said. We could just leave it as variances at the step. So it's what I heard also is that the smaller lots are not buildable. That's what I also heard.
Yeah.
So now we know that. So, okay.
Just so everyone understands, we do not give out septic permits.
Yeah.
But if you come in here for a variance on a 1.5 acre lot, there's going to be a development agreement that you're not turning a shovel full of dirt until you have 2 perk tests. That's the way it works. Okay, we may not issue them, but we can put together a development agreement that protects us from further headaches and frankly the homeowner moving forward, right?
Tim
As part of that
Tim has
process.
her hand up.
So Mayor and council members, that's required for all lots. It's not.
Yeah,
It's a way to say it's a development agreement. What I'm saying is that every lot has to do that. And on that type of
Yes, agreed.
size lot, you would have to go ahead and be extra careful to make sure that that happened before someone got hurt, is my entire point. Jeff, and then let's get this finished up, guys. and move
I'm
forward
done.
here.
What, are we gonna ask for a vote, or if?
No one's interested. There's no motion on the
Okay.
table. Kim, what do you want?
Mr. Mayor and council members, what I would like for the record is a motion.
Well, you would.
To deny amending chapter.
Put that on there then.
I'll also, so
Second. Deny any changes to chapter 32.
Yes.
Keep it the same.
yeah,
Second.
Second, there you go.
Councilmember Carr?
Aye.
Councilmember Rock?
Aye.
Councilmember Kiefer?
Aye.
Councilmember Cornett?
Aye.
Mayor Hubert?
Aye. Thank you, Cam. Moving forward, we have nothing for the city attorney under new business. June 4th, 2024, city council meeting minutes. Ben, we'll need you to abstain on this one.
Oh,
You
that's.
gotta
what we
sit
did.
outside.
Okay.
Yeah.
That's right. I wonder why this was in there like that.
Have to go ahead and approve those because it's in the same month like this. So I need a motion to approve those minutes. I'm sure we've all read them with
I'll approve.
relish.
I'll second.
Second.
Councilmember Carr.
Aye.
Councilmember Rod.
Aye.
Councilmember Paper.
Aye.
Councilmember CORNETT.
That's it.
Mayor Gibbs.
Good job.
Yes, thank you. Yeah. Let's move on here real quick. Consideration of the community festival. Mr. Rock, go ahead, please.
We had discussed several meetings about some form of getting the city to sponsor and to institute the tractor parading. And we've dealt with some things on the budget side, and we have a quote from, as part of the things from the Gas House, Brian Hunter. And the owner has graciously put together that quote for us to use the property, to use the adjacent land where that they do not own, where we used to park the tractors, stage the tractors, allow people to park. And I think there's two aspects that we have to discuss. Is the legal aspects of parking there and having the city sponsor parade something that we want to talk about. And the second thing is the budget for such tractor parade. So I guess I know that Nick had mentioned something about this. I think I asked him to forward some of this information to Nick. And did Nick have some information that he had worked through regarding some of the information that the Gas House had sent?
I think that's a great first question to start with, John, because on something like this, the city's never done this before. So this was done by private individuals. We would be picking that up and running forward with it. So I think you're absolutely right to look for the legal aspects of this first. And Nick, I'm also interested in that if you have some things to say on this. Can you hear us, Nick?
Find my unmute button here. Yeah.
Yeah.
Yeah, so I appreciate the proposal. I think these community events are always sort of challenging, particularly in small communities which don't have a lot of staff to facilitate an event like this. So, I mean, at a high level, I look at this type of event, and my first question is always, who's going to facilitate the event? Who's going to administer it? Are we relying on Kim and the council? Are we relying on folks that we're paying to do work? Are we required here to rely on volunteers? Because, presumably you're going to be dealing with a fair amount of people, and there's a lot that goes into an event of this type, particularly if we're looking at a parade and then hosting 200 people at a restaurant. So that's kind of my first question. As we kind of work through it, then I appreciate the proposal that's been provided by the Gas House. And I look at it from the perspective of what do we as the city need to do to police parking? What do we need to do to police participants and folks that are there? Certainly they want the city to indemnify and hold the property owners free and harmless from any and all liability occasioned by this use of the property owner's land. I'm not exactly sure what that means, because presumably the Gas House will be serving these 200 or so folks that will be attending and participating, or at least that's their estimate. And so, if we as a city are expected to indemnify the operator, that means we're responsible for ensuring that this thing or an event of this type goes off without a hitch, and ultimately that there is no liability, because the last thing that we'd want to see is some sort of a claim against the city or some sort of a claim against the Gast House that ultimately we would be indemnifying the operator against. And so, you know, and they go on to say in their letter that we would, at our sole cost and expense, defend the property owners in any case where there is a suit brought against the property owners under circumstances where the indemnification applies. So again, that's, you know, from my perspective, operationally, that becomes a significant challenge. And then as we kind of work through the proposal, thinking about the use of a particular space within the facility, a fenced-in area for lunch, check-in of entrance. Again, you know, we're not particularly staffed for that. And so then the question becomes, how many volunteers do we need? How many people do we need to pay? And just how are we doing that? And how are we ensuring that things are going as they should? Question with respect to, you know, who's responsible for ensuring that the adults at the event are responsible. Well, we would expect that everybody participating would be responsible. If we are indemnifying the Gast House, then ultimately we're taking on that responsibility and liability for ensuring that all guests and participants of the city are in fact being responsible, and we're making decisions if there are any issues that we're going to step in and take responsibility for removing or correcting folks that are not acting as we might like. So, you know, unfortunately, my job is to spot risk and to be the cynic in these situations. And if we did this sort of thing all the time and we had staff that could manage and facilitate a party of 200 without issue, you know, I might think otherwise. But this is, from my perspective, biting off a fair amount of liability, indemnifying the Gast House for everything that happens on site, and agreeing to defend them against any loss that they might have as a result of any suit that's brought. That's, you know, that's a lot of risk for the city, and certainly from a policy perspective, I think worthy of consideration by the council before agreeing to host an event of this type.
So Nick, I'm going to jump in here. I think the thing that we were only asking you don't have to worry about volunteers or anything like that. We are simply asking you, is there some boilerplate that you could have so that the owner of the second property where we park, not the Gast House, is simply the owner of the second property that wants to be indemnified? Not the Gast House, not the guests. It is just the parking at that second property that the Gast House does not own. That's all we're asking. Don't worry about volunteers. Don't worry about those things. That's we've got that. Okay, so can you put boilerplate together that says that if you sign up or you go eat, that you have to sign up, and especially for the tractors that are parking there and the people that park there, that they have to sign this boilerplate that says that you will not sue this property across the street from the Gast House where you're parking. That's, I think, the question that is presented.
Well, let me answer that question first, and then let me respond to sort of the limitation of the scope. So could we put something together? You know, sure. Is it the city's role to put together a waiver for participants to sign in favor of the adjacent property owner? If that's a directive from the council, we could certainly do that. But I don't think that's the issue here. I mean, ultimately, yes, we could draft a waiver. It's just like if you go to a ball game or if you go to anywhere else where you've got to sign away a right to file suit. We can certainly do that. You know, how you administer that is you're gonna have to have somebody out on that property handing out waivers that people sign on site, people who park in that particular location sign on site. But you know, we can get there through drafting. I don't think that's the sole issue here though, because if you look at the letter specifically submitted by the Gasthaus, it has a number of these other issues sort of woven within the proposal where they're asking the city to take on indemnification and liability. So that's the only reason that I commented on those points, because ultimately those are risk issues from a legal perspective that the council should consider.
Nick, maybe I'm not a lawyer, but it seems as though the only thing that they're asking is about the property across the street from the gas house.
Can you reference a specific language that you're concerned with regarding the Gasthaus and acceptance of liability in the city's part, please?
Is that me?
Trying to ask Nick.
Well, I'm just looking at the letter. So first, the city requests to use the field east of the Gasthaus across from Lofton Avenue. Gasthaus does not own this property.
Hang on, I got one. It says
Hang
the
on a
property
second.
owners.
Let
Okay,
the
sorry.
lawyer go through it first, and then we'll get comments.
I was just trying to get.
Yep.
Yeah, so essentially what they're asking, and if this does relate solely to that field, that's fine, but it's still asking the city to provide a written indemnification, keeping and holding the property owners free and harmless of any liability. And so, you know, specifically with respect to that property, this isn't necessarily a situation where they're asking that those that park on the property sign a waiver and release the liability. That would be presumably the city agreeing to indemnify that property owner, seeking waivers from the people that park there that say that they won't sue the owner of that property, because we're asking, because if they do, then we're going to be responsible. Right. So, I mean, we're trying to, if what I hear is, if I'm hearing it correctly, we would be asking for waivers for our own protection, because we will have agreed in this respect to hold the owner of that property harmless if there are in fact any claims against that owner. So it does put the city directly in the middle of that particular issue with respect to the field east of the Gasthaus. Where they would park, I guess.
Yeah, thank you, Nick. We'll try to keep it quick here and really succinct, Tom.
Well, to John's point, I think it says owners, not owner. Is there one owner of the field or two?
It was from what I gather, it was the father passed away, and now the sons were sons.
So it's one property. So when you
One
say
property.
owners, that could be misconstrued to be in the Gasthaus and that property.
It's just the property.
I know, but it says owners.
Yeah.
That's all.
Poorly phrased, Tom's
Yep.
right. Nick, a couple other questions for you. I forget the name of the particular liability and insurance that covers it, but when you serve alcohol for money, there's a particular type of insurance that you need to make sure that they're not overserved and they cause some type of mayhem on them leaving the bar. Is that something that the Gasthaus would be responsible for, even though we have our residents, we paid for them to be there? And if they're drinking alcohol, it's a complex litigation nightmare, it seems like to me. I don't know. You tell me.
You're talking about dram shop liability for over service. I mean, that's certainly one issue that we would want to talk to the Gasthaus about is, you know, presumably how they would operate. This is a city event, a public event held at a private establishment. Again, you know, what responsibility are we taking versus what responsibility are they taking? Obviously, they would serve, and we would not be responsible for that. But where does that split happen? I mean, are we required to do anything? Are we required to marshal participants, or is that the guest house role ultimately to serve 200 and also, you know, make sure that that it's only the 200 people who are invited on behalf of the city and nobody else is in or whatnot. So, I mean, it just without knowing more, it's really hard to say where those lines are going to be, because obviously the Gast House will be responsible for some aspects, but presumably the city will be responsible for other aspects of the operation of this event.
Okay. Another question for you. I hung around one of these one time. They actually closed down McCusick for a portion and then go up the other road. I forget the name of it, but would police be required? Would we have to actually hire police officers to actually direct traffic, keep traffic from running into the parade? I mean, is that something that we would need?
Well, presumably traffic control of some kind would be required, not necessarily law enforcement, but you're going to have, you know, clear demarcation of what's open and what's closed, what the detoured routes are, if there is some sort of a detour. But, you know, obviously you're going to have parade staff who are either city staff or volunteers directing traffic.
I was concerned about that in terms of, again, if they're directing traffic to get run over, it's going to be our problem. If it's police, they're covered through their own insurance and the whole thing, which is usually the reason why you have police at these things and not volunteers in a yellow vest. So just wondering on that. Other questions, gentlemen?
Jeff, one other thing, I'm sorry, I should have mentioned, Mr. Mayor, the concept of a limitation on attendees is somewhat challenging in the municipal sense, in that the council should consider, if it's going to spend dollars on a public event, that those are taxpayer dollars that are being allocated. And if there is a cap, and if more than 200 people want to participate, but you do have that cap, there's sort of an interesting conflict between spending public dollars for the benefit of the entire public and a limitation on who can participate based on effectively who shows up first, getting to your cap. So there's a bit of a conflict there if in fact we are looking at a hard cap on an event like this.
I don't know if just chime in. I don't know if there's going to be the tickets, all that stuff. I think every resident that wanted to go should be able to go. And so I'm sure that the Gast House has overage planned. And if we needed more, we would have more. So I'm not going to say that only people that are in the tractor parade are the only people that can eat, because I'm sure that there's people on the parade route or local houses that are part of it that would want to go to the Gast House. So I'm not going to, you know, I don't think the ticket scheme is going to work. I think we need to open up to the citizens, and everybody that wants to go can go, and we'll have to work that out. But I don't think having a person at the gate checking tickets is the right way to go.
I would agree, but to that point, I'm not sure if the Gast House really understands, based on that letter, what I read in that letter, I don't know if they understand all what's involved in pulling off something like this. You mentioned that there would be no volunteers needed, but who's going to do? To me, it seems like if we could get a project manager type plan from them, like to understand everything that needs to be done, who will be responsible for the activities, when will these activities need to be done, so the who, what, why, when, where, any dependencies, and then, you know, who's responsible for the cost. I'm not so much worried about the cost in the budget. I think we could find that. It's just me, the planning and scale of this. You mentioned now that, you know, this might be much bigger than they intended. How will they be able to handle that? If we see some more concrete, like project plan type information from them, where they have these contingencies, you know, parking, insurance, signage, police, printing flyers, how they, you know, all these things. If we saw more detailed information on that, then I think would be better for us to make this.
Yeah, I don't know if they are responsible for flyers or billboards or posters. I think that's probably in the city's plan for the budget. I think that's us. I think the volunteers, I mean, they have the volunteers for
But you make
serving,
my point that we need a project plan that says who's gonna do it.
right? But I think the volunteers, we need to, you know, have volunteers from the city to, you know, and to just point the, I think a police officer at the station at McCusick to stop the traffic from going where the parade route's gonna go. You know, all you have to do is think back.
Yeah, and I'm not
That's
just,
involved.
and I'm not trying to, I mean, I'd be willing to volunteer to do some of these things. I'm not trying to poo-poo the idea. I just think that we need to be really organized around, and make sure that Goshawk understands what they're stepping into.
Yeah.
And it's very clear, as Nick said, who's doing what, when it's gonna be done, and who's responsible for the liability. So I'll yield.
Well, to Jeff's
Tom,
point, this is, I just was listening, but yeah, I mean, I think if you're gonna be an event center, which I don't know if the Goshawk is, then you need to be an event center. And we shouldn't be asking all these questions. They should just have it all ready to go, and this is what it's gonna be, this is what it's gonna cost. You wanna have an event, come and have an event. If you're not an event center and then you're dabbling in it, it becomes very problematic for everybody and a lot of work. And so I that's my only thing. I know what John's saying. I certainly don't want to, like I said, I don't want to get sued. I don't want any problems with that, especially for the city, but there's all kinds of things that come up that Nick said that I tend to agree with. On the other hand, you gotta start somewhere. So
Yeah.
maybe it's not this year, maybe it's next year, maybe the Gust House gets a plan together. So if they want to have events, they used to have events, they had October first. So I'm done.
Mr. Mayor, council members, I just wanted to note that the.
Hang on a second, guys.
That, put this on, they did have Washington County deputies out there.
Yeah.
Directing traffic, they also paid them.
Yeah.
They don't come free. And then I guess, John, to your point, that you can't limit it. Everybody should, all of Grant residents, my question would be, how are you gonna limit?
Yeah.
it to Grant residents?
You're no more.
Because we had the same thing at cleanup day, we had to start asking for driver's licenses. I had been to that event with one time, and not that I know everybody in Grant, but I would guess that probably half of them were not from Grant. And my concern would be based on the proposal, if you do open that up to everybody and everybody eats, what are those costs gonna come back at? That could easily double for the city, especially if you're getting other residents or other people from the communities come to meetings. I
Ben,
don't think
please.
they're gonna argue for these.
No. Go ahead, Ben.
I have a question for Nick, if you can. So I was just reading through it and they mentioned serving alcohol to the people driving the tractors. What is our liability of something happening during the parade? Like, where do we stand on that and what would we be opening ourselves to?
The actual serving is after the.
Okay.
You don't know if they're drinking in the parking lot beforehand, before they get on the
That's
trailer. We're just looking
Yeah,
for
so
liability.
The way I read it, it just said, open to serve alcohol. I didn't know.
Yeah, Nick, do you want to go ahead and just answer that? If there was some type of alcohol-related accident on the road, does that liability transfer to us? It's our road. How does it work?
Well, it depends on whether we've done anything to contribute to the accident. So, I mean, if it's a rogue actor that drank alcohol prior to, and we've seen some of these things before where somebody drives off the road or something like that, that's probably not going to be our issue if we had nothing to do with it. If we, though, had a situation where we were directing traffic and one of our volunteers didn't direct traffic properly and there were a car tractor collision or something to that effect, then we may have some liability. So it's a question of, whether we've got it sufficiently planned out so that ultimately we're eliminating the major risks. And if something intervenes, it intervenes, and that's somebody else. But again, it doesn't stop a claimant from making a claim that the city negligently designed its parade route or negligently did something. but that's what you have insurance for. So, but it is a matter of having a sufficient plan. And I think there have been a number of comments to the effect of, let's take some time and make sure that we've got the details planned out if we're going to do something like this, so we've got all of our bases covered, so that we know exactly what the risks are. And I would echo that sentiment.
Thank you, Nick.
Yeah, okay. Nick, I want to go back to the waivers for a second. You were talking about attendees showing up and having to sign a waiver. And this, I may be getting deep into the weeds here, Nick, but if we issued tickets with the waiver on the back and those tickets were taken at a gate, would they not have agreed to the waiver?
Well, it depends. There's case law that certainly doesn't prefer required waivers in order to participate, right? So at least if I go to a Twins game, I'm making the conscious decision that I'm going to pay my $50 and I'm gonna go in, and those are, it's my dollars. Here, if I'm required to sign a waiver to access a city event where taxpayer dollars are being spent, I think there's an argument that waiver may not hold water, just given the fact that I'm accessing city services that are available to everybody else. I shouldn't have to waive my rights to avail myself of use of those taxpayer dollars. So it's not automatic, certainly.
Okay. All right. That tells me a lot about the liability aspect of it in terms of using city dollars. And I will echo the sentiment. I think everyone, Tom, our attorney, and the gentleman down here are perhaps looking for more detail. I would like to see Gas House produce a stepped set of pricing depending on the amount of people that come. If I'm spending these people's tax dollars, I think I need a little bit more detail than this. So that would be kind of my position on it. Jeff?
And, kind of along those lines, this has been done before. It's not like, it's not, insurmountable task. Have the people that are currently under the ownership, the owners of Gas House now, John, were they part of the prior thing? So they have a template to follow?
Yeah, they have that's where the numbers came from.
Okay.
They said that they've done this in the past for 200.
So they handled all those things that we talked about, the signage, the police, all that
Well,
stuff.
they didn't provide posters. They didn't provide.
Okay, well, whatever it was,
sign-
yeah.
But you know what I mean, though. They provided food, speakers, the sound systems, all the stuff that was used before. The other things that were on the people, those posters that were sent bulk to every resident, and the banner that was on the corner of 96 and Chambers.
Okay.
So those are the things. And then obviously the trophies that they purchased. Now they did have raffles to help defray some of those costs.
Okay.
If you remember. But
Yeah,
either way.
It would be nice to see those details, to see, how they pulled this off before and how they divvied up the responsibilities and, yeah.
Kim, you don't need any sort of action on this. We need to move on. We're kind of beating this one to death a little bit.
Mayor and council members, at this point, I would like some sort of motion because it is an action item and for your annual,
Sure.
That motion can be whatever you choose.
Gentlemen, we're looking for a motion. You can approve, you can deny, you can say awaiting more
Mr.
information.
Mayor, council members, the motion is simple as to not move forward with this at this time.
There we go. Kim's always a good one with the suggestion.
John, it's your item. What would you suggest?
We've been doing this since I think March, and now it's the end of June, and now we're looking for more information. It would have been nice when I first brought this up if you guys had mentioned that earlier. We could have done this. We could have pulled this off this year had we known all the information, all these questions that we've been going through since March. So I'm disappointed. I'm going to put a motion out there to proceed.
We're good. Do you have a second?
I'll second it for discussion.
Go ahead, discussion. Anything? We taking a vote here. You can discuss it.
So what does proceed mean? Proceed means
He wants to move forward with it. He wants to barrel ahead.
First week of September.
First week of September.
okay, that's the motion, okay.
Ben, question for discussion? It's up for discussion before we vote on it. Then I'll call the vote. Okay, I have the information I need. Tom?
Friendly amendment, just so,
Yeah. It's-
we're gonna move forward with more information at the next meeting at final. Would you accept that?
Okay.
I would
Okay,
accept that.
so we'll,
I'll accept that.
it'd be the last time, to John's point, he didn't get enough, we're gonna get enough for next meeting and make a decision. How's that? Is that okay? Okay, well, that's
If
my,
you
that's my,
accept it, you
I
accept the
accept it.
friendly.
Okay.
Okay, real good. Call the vote, Kim.
Councilmember Kern?
aye.
Councilmember Rock?
Aye.
Councilmember Biefer?
Aye.
Councilmember Cornett?
Aye.
Okay, it's
Mayor
unanimous.
No.
Nope, not.
No way to do it. All right. 2025 budget work session. Kim, do you have something planned out? You got a date in mind?
I most certainly do, 1 hour previous to your regular August council meeting. An hour or a half hour, I think that's up to you guys, you typically do 2. But with the cost of everything, gone sky high, you might need some more time. So I am proposing your meeting is August 6th, 5:30.
5:30?
What day? Right before the next.
Just for the meeting, an hour
6.
before.
Yeah, we come in real quick and discuss
We'll
it.
have to have one
All
in
right.
September.
John, you have a question for Kim?
I'm just gonna say, I will get all the information to you gentlemen before the August meeting. Okay?
Yep.
It seems as though I'm not going to be here for the August meeting,
If you need help, John.
You're not gonna be here for the next meeting?
not for the August meeting.
Mayor and council members, I would note that we need that information for the packets.
Right.
Yeah.
The week before.
Yeah,
Okay.
so I will put that together.
Okay,
So
5:30.
5:30, August
Yep.
6th.
yep.
Okay,
Kim will let you handle the assessor appointment.
why don't you go ahead and make a motion, so we're doing the same procedure, it's part of transparency and announcing meetings for the August 6th work session.
You'd like me to what, make a motion on that
I'll-
one?
also
Oh my
move.
God, we already
Yeah.
did that.
I'll second.
Thank you.
Councilmember Carr?
Aye.
Councilmember Rock?
Aye.
Councilmember Biefer?
Aye.
Councilmember Cornett?
Aye.
Mayor Gibbon?
Sure.
Mayor and council members, consideration of assessor appointment at your last meeting. You appointed an assessor, private assessor, Ted Anderson. Theodore Anderson. I had been in touch with him throughout the month, got the paperwork in, got everything submitted. He contacted the county. They needed some stuff from the city to put him into the system. The next day, he sent an email that said he does not have time for the city of Grant. And
That's
I
strange.
sent that out to you.
I like them a lot.
I did, respond to him on Monday, this was on Saturday, and said I was very glad to hear that. May I ask what changed your mind about working in the city of Grant? And he said I was looking at my summer and fall schedule and realizing that I wouldn't be able to provide the quality of work that I would expect to provide in the time allotted.
Huh.
So that being said, we had another proposal from Patrick.
Polchek?
Polchek, yes, and his pricing was 27,600. We had a proposal from the county at 38,700. And I did get in touch with the Delwood, Birchwood, Marine, St. Croix assessor, private assessor. His name is Chase Elfwin, but there just was not time for him to give me a proposal because it's tonight.
Can we? I don't know.
It starts July 1st.
So we can't wait to hear from those guys.
I guess I would refer that to Nick. Can the assessor, can you go without an assessor for a month? I don't think so, because it's on a cycle. And it starts,
You'd have double the work.
Todd
Hang on a
Smith,
second. She's
Yeah,
asking
no, I
me
know.
to make a question. Yeah, so I
his
guess,
license is expired June 30th. That's why it gets in place in July.
gotcha. Is Nick still on the line or not? Nick, we still got you?
I'm here. Yep.
Okay, Kim has a question for you, I believe, on the assessor.
Nick, if the city's assessor, his license expires, the current Todd Smith license expires June 30th. and we wait another month, the city waits another month to appoint an assessor in, August. Is there an issue with not having an assessor for a month, other than the cycle and the timing?
No. No, I mean, obviously there's nothing we can do about Mr. Smith and when his license expires. And, either we have somebody appointed to replace him on that date or we don't. Certainly I'd recommend doing it as soon as possible, but if we need to wait until August, we can certainly wait until August.
Nick, we have two other proposals on board, which the council has gotten all that information. It's from the county and another private assessor. And that was all presented last month to the city council. The only reason the council might want to consider waiting till August is to get pricing from another private assessor. But again, that would put the city without an assessor for a month.
And
Tom's first, hang on a second. Did you have a question?
my question to Kim is, did that person that you found seem interested?
Yes,
Well, then I won't want this.
We can,
And,
go ahead.
and
Go ahead.
it sounds like they had, experience in the area, surrounding areas that,
again, I just would like for Nick to comment on if it's okay. I don't
Right.
know.
We can table it.
Yeah.
they-
Yeah,
It.
yeah, I'm sorry, but the only question I would have is whether we need an assessor to do any work during the next month so as not to get behind on any deadlines. If that's the case, then we should move forward with an approval of one of the recommendations. If we can afford to wait, and if it's not going to create any issues with the assessment deadlines, then you're certainly welcome to wait for another month.
Yeah, makes sense, Nick. Kim, just a real quick question. If we were to hire an assessor, is there time in our assessment timelines to make that a reasonable assessor? You've worked with them for years and years. Is there enough time left? If we hold off for a month, can they get all the assessments done and reported to the county in time?
Yes, that's not done until like next January. It depends on their workload. They're he's starting a month late.
Thanks for answering my question. I appreciate that. Jeff, you're next.
Tom's next.
Go ahead.
Oh, thank you, Jeff. Yeah, I've had assessors do a lot in 2 months. So
All right.
that-
Yeah, I don't know
So
what the
here's the
workload
other thing. So you talked to, this other assessor that wants to put the bid in. I'm assuming they're gonna be probably comparable to we don't know. Okay, because the only thing I would like to do to clean this up, just for my benefit, I mean, I would, trusting what you talked to them, they're working and dealt with it, working everywhere, make a motion I would make a motion if the council would accept it, that we go with that assessor as long as the pricing and everything was comparable to the other two private assessors we had. And then we wouldn't have to worry about it. If it's not, then we don't, and then we can revisit it in a month. So I don't know if that's something we could do.
Mr. Mayor and council members, if you do that, you certainly can.
Yep.
I would put a cap. I wouldn't use.
Yep, no, I know. And so what was, I can't remember what was Pat's.
Patrick was 27.6. I think Ted was the same.
So anything
Yeah,
under
well,
30
30.
bucks, 30 bucks, exactly, read my mouth, $30. And if it is,
30,000.
or 30,000, I'm sorry. All right, I thought it was per parcel. No.
Well, that's what that equals. out.
Oh, got it, yeah, I got it, okay. So if the council would want to take a motion like that, I would make.
Can I make a motion?
No, you can't.
Nick,
One's
would
on the
that be
table
an
right
No,
now.
I'm just asking, I'm just
I didn't
polling
know
the
you made-
council,
I was-
if you wanted to, if not, I'll be quiet.
We're gonna hire an assessor. Let me make sure I understand.
Yeah.
We're gonna hire an assessor who we've never met, haven't seen any paperwork on him, haven't checked his references, have no idea
Yeah,
if he's at a certain price.
no, that Kim talks to him and make sure we get, and we can get the information, he's at the right price. Don't have to delay. We've done it before on different things.
Why not
We
just
don't have-
delay? and get
We
all
can,
the
I mean, I know we
information?
can. I just was trying to clean it up.
Yeah, we don't need to clean it up.
Okay,
Sorry,
we
told us
can
we have a
go a
month,
month,
so,
that's
yeah,
fine. I'm just why I was asking.
We got a month.
I make a motion, we table
Yeah,
the decision
that's fine.
until next month.
Yeah, then we have all of our,
No discussion.
ducks in a row.
Motion to
right?
table.
Yeah.
I'll second it.
There you go.
Councilmember Hart,
Aye.
Councilmember Rod.
Aye.
Councilmember Bieber.
Aye.
Councilmember Cornett.
Aye.
Mayor Hubert.
Aye. Any unfinished business, Kim? Nothing? Any updates? City council reports, gentlemen?
One thing, do we have to vote on this resolution for election judges? Is that in the-
That was
Is
in
that
your
a consent
consent
agenda?
agenda.
Okay, I couldn't remember. All right, thanks.
All right, no city council reports. Mr. Cornett, I'm gonna have you read our community calendar for the city, please.
Matamidi Public School Board meeting Thursday, July 11th and July 25th, Matamidi District Education Center at 7 p.m. Stillwater Public School Board meeting Thursday, July 11th at Stillwater Hall, 7 p.m. Washington County Commissioners meeting Tuesdays, Government Center, 9 a.m. With that, I make a motion to adjourn.
We have a second.
Second.
Nice. Kim?
It was Jeff.
Councilmember Carr?
Aye.
Councilmember Rod?
Aye.
Councilmember Bieber?
Aye.
Councilmember Cornett?
Aye.
Mayor Hubert?
All right, thanks, Kim. All done.
All right.
Good job.
Thanks, guys.